And welcome back inside Brunch from 107.7. My name is Rennie Bishop. Nice of you to take the time to be with us. We are particularly appreciative that it is your Sunday and you have a lot of things to do. We are also equally appreciative of our guests when they take up their time to be here. Like my next guest is attorney Hyacinth Griffith. She's a practitioner working in Trinidad and Tobago, and she specializes in the area of adoption, child custody, parental child abduction, child protection, and marriage. The common feature in Trinidad and Tobago. First of all, let me say thank you so much for taking up your time this Sunday, making the arrangements to be with us.
I'm glad to be here.
And I thank you very much. The common feature in our diverse culture is what is known in law as cohabitational relationships. This is where two people have been living together as man and wife without having gone through the official ceremony of marriage. There was an act passed in 1988. It's called the Cohabitational Relationships Act, and it recognized the existence of such informal unions. It granted to these many people the same rights in relation to property and maintenance which a wife or husband in a formal marriage ordinarily would receive. So speak to us as we start on this area of what is a habitational relationship.
We have the opportunity in the Caribbean to have had a history of having relationships which are not strictly marriage, but they approximate marriage in so many ways. And what has happened in terms of the Caribbean experience is that we have very strong bonds and relationships which have a lot of history. And there is, for those persons who are engaged in that relationship, they will contend that they are relationships which involve commitment, and quite often they are monogamous, and they also produce children. But historically, coming out of our common law experience, we did not recognize cohabitational relationships. And what we recognized in terms of legally being entitled to inherit and to share in the estate and the interest and so on were marriage. And we had our matrimonial proceedings, the legislation and the rules which guide that. Now, in the government then recognized the need to pass legislation which would protect those relationships, persons who were engaged in those relationships who previously had no remedy. And so there was the act which was passed in 1998. And it came on the heels of some cases, and in fact comments from the court. And one of the very well-known comments that had been made was that of our former Chief Justice, Sharma, in the case of Harry Narayan and Aziz in 1982, when he made the comment that we must look at our own society and determine when a common intention can be inferred. In our society, the common law marriage has been institutionalized, and even Parliament has recognized its importance and existence. However, although it had been recognized, there had been no formal legal framework to protect those persons who were engaged in that relationship. And so that's what gave rise to the cohabitational relationship.
So
Act.
the question is going to be, who qualifies as a cohabitant?
Well, the Act actually provides specifically where that is concerned. And I think that perhaps I should indicate that a cohabitational relationship is not and has not been recognized by the court as a marriage. The benefits are not the same. What you are required to establish in terms of benefiting under that piece of legislation is not the same as that is required in terms of a marriage, so that it is completely different. It is a different relationship, but it is a relationship recognized by law. So that a cohabitational relationship, really, what is legally, they recognize it as a relationship where there is one which is on a bona fide domestic basis. And that, of course, is legal jargon, but basically the court looks at different aspects to determine whether or not there's a bona fide domestic relationship. The intention of the parties, the commitment, the shared purpose, the financial dealings that they have, the way that they have conducted their life and how they have lived. And that is what will inform the court in going forward in terms of making, first of all, a determination that there is a cohabitational relationship, which must be established before you can, in fact, be entitled to claim the benefit under this legislation.
Some of the areas I saw is you have to cohabitate for no less than 5 years.
Yes.
Have a child from the relationship, or a person applying made substantial contribution to a home,
Yes.
whether financial or non-financial.
Now, it's not all of those categories. Essentially,
Either of.
you can have you can qualify if there is a presumption, or the presumption rises if there is in fact a child born out of that relationship. But if you have been in a relationship which is less than 5 years and there is no child born to that relationship, then you will not in fact qualify, because you will not have satisfied the requirement of the legislation.
That is one of the areas that I found a bit difficult to digest, because, I mean, one can go as far as 4.5 years, 3 years, 2 years, and really, unless there's a child in that relationship, you are really unprotected.
Well, the thing is that there is the legislation and the reliefs that you're entitled to under the legislation. You must establish that bona fide domestic relationship. And if it is that there is not a child, one of the things that can assist you in terms of establishing that is that you have made a substantial contribution. And that substantial contribution can be what we speak of in terms of direct or indirect contribution. And indirect contribution is not... We know direct contribution being money, but there are many of these relationships where persons really are not able to establish that tangible monetary contribution. But indirect contribution is also recognized legally, so that you can make a contribution to your family, to the home. You have, in fact, you have taken care of your partner. You have taken care of his children. You have done things which the court will recognize as being the foundation for establishing that bona fide domestic relationship.
Maintenance being paid. So those are some of the metrics you just identified they used to calculate the substantial contribution. Is that correct?
The maintenance?
Well, yeah, because there's a part here where I'm looking at the law where it states that part of the relief that can be given is where folks are sent on training, educational training,
Yes.
and so on, as a way of as relief. And I'm trying to work that out as against just straight money, as you said.
Yes. So that if you have, for example, you might have been in a relationship and that relationship has come to an end, but you have not been engaged in working during that period, and the relationship has come to an end. So essentially you are not in a position to earn adequately to take care of your needs, and because your partner previously provided for you. So that the court can make provision, as in a situation where a marriage has broken down, the court can provide for you to be prepared for the workplace, so that the court may give directions for you to receive training. The court can also provide for you to receive maintenance for a period during that period that you are doing that transition. Under the Cohabitation Act, however, the period that you will be able to receive maintenance is much more restricted, so that the Act actually provides for maintenance for 3 years. However, it can be extended for a further period, where you find that in the Matrimonial Proceedings and Property Act, maintenance at the very outset, the court can make an order for maintenance to be paid for the duration of your natural life.
That's the demarcation line.
Well, that's one of the considerations, the differences in terms of the application of the legislation.
One of the curious areas in looking at this, and please set me right on it, because I brought it into studio, and at the time there were only male gender here.
Yes.
Two questions came up. One, is this gender neutral? Because men always get the wrong end of the stick is one way of thinking, but more importantly, or maybe equally importantly, is the area of, if the man is married, but is not with his spouse,
Yes.
he has moved out of the house, and now he lives with somebody else, let's say arguably, who was also married, moved out of her house,
Yes.
and now they're both together
Yes.
in that kind of relationship, and they go into a 3-year 5-year period, they meet the bar, for instance, for cohabitation.
Yes.
The claims can still be made of either party, because
Yes.
what that means is that the legal wife, if they are not divorced, now gets into a battle for the division of assets.
Well, it arises most strikingly in the event of the death of that person.
Yes. Mm-hmm.
But in the context that everyone is alive,
Mm-hmm.
we can deal with them separately. In the context where everyone is alive, certainly you can be married and in a cohabitational relationship with someone else. It is a part of the reality of the Trinidad and Tobago experience. And so that the question of marriage the fact that you are married does not debar you from entering into a bona fide domestic relationship with someone else, and for the court to find that you are in fact in a cohabitational relationship with that person, such that that person is entitled to relief under the Act.
Mm-hmm.
Now, that is in the context where you are alive, and it also obtains where you are deceased, because the Act provides that a cohabitee is also entitled to and can claim a benefit under this Act in the event that you die, so that that cohabitee can actually make a claim in respect of your estate.
He or she gets relief from the court, and they get whatever they get from it. You say the initial period is for 3 years, and it can be extended. But because both of them are not in their relationship, they could get the divorce in the meantime. Forget about the divorce part. Let me just deal with the fact that there is a settlement from the court, and either party in this now cohabitation relationship, under the 3-year period, they move into getting married with somebody else, or move into a different relationship with somebody else. The relief afforded them by the court from the initial cohabitation situation, is that generally renewed? Is that ended at that point?
No. If you have received, if in your capacity as a cohabitee you have brought proceedings,
Mm-hmm.
either the relationship is at an end or the relationship is ongoing, and you have sought relief from the court, and the court makes an order that you are entitled to that relief,
Mm-hmm.
you are entitled to that relief.
And if your circumstances change within that 3-year period that is initially put
well, in terms of change, in terms of the nature of the relationship, the cohabitational relationship, or your financial position changes.
Well, that you're now into a new relationship.
Oh, that does not preclude
Nothing to
the
do with
person who is entitled to a benefit. In other words,
Mm-hmm.
someone who is entitled to a benefit is entitled to that benefit, and if the court makes that order that you are obliged by virtue of your previous partner to make certain payments,
Mm-hmm.
you would be obliged to make them even if you have moved on in your relationship. And the same happens in terms of a marriage. If you have been married and the court makes an order that you are to make certain payments in terms by way of financial relief to
Mm-hmm.
your wife, the fact that you may remarry does not mean that your wife is not able to recover that benefit.
Mm-hmm.
So that in that way, an order of the court is not overtaken by the fact that you move on in the
Change events,
relationship.
yes. Mm-hmm.
There are circumstances, and especially in terms of a cohabitational relationship, where the change of your circumstances may result in your application dealing with maintenance. And this is why, as I said, it is where you're dealing with maintenance, it is an ongoing obligation. And the court has the discretion, if it is established that there is a change of circumstances, to vary an order with respect to your maintenance. But that is in respect of maintenance. But if the court makes an order that you are to receive a lump sum, that is not an order that is going to be...
Understood. The maintenance area is what I should have been more
is
specific
an area
on.
where the court can, in fact, intervene by
Good.
virtue of your change of circumstance. But the change of your circumstances is not just a matter of changing from one relationship to the other. It must be reflected in terms of the change of your financial position. And it is that you have to satisfy the court that your financial position is now worse or worsened by the events of time,